we'll go ahead and call Mr. Smith's matter if the parties want. That is 25T435. Mr. Smith appears before the court pro se, meaning without an attorney. The last time that we were present, Mr. Smith had sought to relieve court-appointed counsel of her services and did not request new court-appointed counsel, thereby electing to proceed pro se. Mr. Smith, how would you like to proceed in your case?
I filed a motion just this morning. I'm not sure if
it hasn't been filed with the court yet, meaning they haven't uploaded it yet.
Yeah, I hand delivered it just this morning.
All right, so we're looking to schedule a motions hearing?
Yes.
And what type of motion to put the people on notice?
Dismissal.
On what grounds?
Violation of constitutional rights.
All right, so a constitutional based motion. Are you alleging a violation of a particular section? Or are you alleging that the statute itself is unconstitutional?
It's predominantly the Fifth Amendment, 14th Amendment, in regards to legal counsel and due process.
In regards to legal counsel, you fired your attorney at your last appearance. You haven't sought appointment of a new attorney. In what way have your rights been violated there?
Well, on September 30th, when I was summoned to court on the court's docket to courtroom 103, I went over the building and was unable to find it until I finally intrigued with the guards who pointed me in the direction of the clerk's office. With that being on the docket as a courtroom and the possible consequences of failure to appear that comes with more fees, fines, and possible jail time, I'm not sure why that's in the clerk's office where I was isolated behind closed doors without that legal counsel, which was before.
So in that instance, you're referring to a different case, not this case, 25R549. So nothing in relation to that case is going to be referenced in this case. To the extent that you're alleging other violations, though, we'll set your motion for a hearing. Keep in mind that motions deemed to be groundless, frivolous, vexatious, or otherwise contrary to law will not be heard. But I don't have a copy of the motion at this point, so I can't make that determination. We'll set it for a hearing on motions to the extent that any of it relates to this case, not some other case. And let's get a date.
Your Honor, I do have paperwork that does say that that is for the 2025R000549.
Right, that's a separate case. This is 25T435.
Okay.
Infraction cases operate under a separate set of rules, and those do get heard for first appearance at the court clerk's office. The case that you're before the court.
Before we even hit play on this courtroom exchange, you need to understand something. This case was already heading toward disaster long before the judge even said a word. We're dealing with a defendant who made one of the most dangerous decisions anyone can make in a legal battle. He fired his own attorney, not because she was incompetent, not because she abandoned him, but because she refused to argue something that simply doesn't hold up in court. Now here's where it gets interesting. Instead of adjusting his strategy, instead of trusting someone trained in the law, he doubled down. He decided, you know what? I'll represent myself. And if you've ever watched cases like this unfold, you already know how this tends to go.
Than what you would have been initially for a first appearance authorized to appear in room 103 for the basis of, not the number 4. So again, we won't be hearing any contentions in relation to anything about the infraction case. I'll let you know as well that people are not entitled to have court-appointed counsel in infraction cases. But again, that's separate and apart from you're entitled to have hired attorneys, but the legislature does not authorize public defender or court-appointed counsel or similar to appear on those. And in addition, the district attorney's office doesn't appear on those cases either. All right, for a hearing on motions in this case, I can set a motions hearing on April 1st at 1:30. Can the parties accept that?
That was April 1st.
April 1st,
Yes, ma'am.
1:30.
Yes, ma'am. That is fine. At 1:30.
Correct. As it relates to this case, Mr. Smith, again, 25T435, we had some of this conversation last week. I just want to make sure to clarify on the record when the people are present that you are electing to proceed to a motions hearing and moving forward in this case by representing yourself. Is that correct?
I'm still in the midst of studying and trying to understand my own rights. So it's a challenge. It definitely is. I'm not going to lie about that. So the representing myself is still, I'm pending it in my stance of everything. Just because I'm in a financial hardship, so finding a free attorney to take the place of a public defender it's almost impossible.
Mr. Smith, I want to reiterate that the last time that we were here, you elected to essentially fire court-appointed counsel and proceed by representing yourself. Is that correct?
That was because I was under the impression that she was unable to defend me.
Unable to ethically file the motion that you sought her to file. Is that correct? According to her.
According to her, yeah, I'm sure.
And you did not seek an alternative defense counsel to be appointed to you. You elected to proceed without the benefit of an attorney at that time. That doesn't mean that you waive your right forever if you can find an attorney, but you were not requesting alternative defense counsel to be appointed to represent you, correct?
No, Your Honor, not from the courts.
And is anybody forcing you to decide to, at this point, represent yourself?
I feel more pressured into it, yes, Your Honor,
In what way?
because I don't have the defense of a public defender.
You had one, you fired her. So in what way are you being forced to do this?
I didn't necessarily fire her, Your Honor. When she refused to even hear me out when I mentioned a few words, that's not, in my understanding, it's not firing her.
We
I
had
was
a
pretty
pretty
shut down.
lengthy hearing on the last court appearance, Mr. Smith. Do you recall that hearing on the 9th of January?
Yes, Your Honor.
At that time, you no longer wish to have the services of the public defender, is that correct?
Yes, Your Honor.
And you did not seek appointment of alternative defense counsel, is that correct?
Not from the courts, Your Honor.
So that's correct, yes?
Yes, Your Honor.
And did anybody force you to do that?
No, Your Honor, I still feel pressured into it, though.
In what way do you feel pressured?
Your Honor, I was under the understanding that I have the right to an attorney, and if I cannot afford one, then one will be provided for me.
One was provided for you, correct?
Provided for me in the stance that she would not defend me.
And you did not request alternative defense counsel to be appointed to represent you, correct?
Not from the courts, no.
So nobody forced you to make that decision, is that correct?
Yes, Your Honor.
Was that your own choice?
Under coercion, yes, Your Honor.
Who coerced you?
The pressure from representing myself in this. I was under the impression that's what you guys were telling me, was since the public defender would not defend me.
Right here is where things start sounding serious, but only on the surface. Anytime someone brings up constitutional violations, it immediately grabs attention. It sounds powerful, it sounds legitimate, and it can even sound convincing if you don't know the details. But here's the problem. In court, you don't just say, "My rights were violated," and expect everything to collapse. You have to be precise. The judge immediately tries to narrow it down. Which right? What violation? What law? And that's where weak arguments begin to fall apart. Because if you can't clearly connect your situation to an actual legal violation, the entire claim becomes empty. And as you're about to see, instead of building a strong legal foundation, he starts drifting into confusion that's going to hurt him more than.
Yes, Your Honor.
Are you under the influence of any drugs, alcohol, intoxicants, or prescriptions that affect that decision?
No, Your Honor.
Do you understand that you're going to be held to the same legal standard as a licensed attorney?
I'm still under study and research and education of myself.
Do you understand that you're going to be held to the same standard as a licensed attorney?
To an extent, yes.
I'm telling you, you're going to be held to the same standard as a licensed attorney. Do you understand that?
Yes, Your Honor. Do I need a
I'm not asking if you understand all of the things that licensed attorneys have had to go through in order to be licensed. I'm asking you whether or not you understand that the standard that you will be held to is that of an attorney.
I understand that part, Your Honor. I just don't understand the standards that they are functioning and operating by.
And nonetheless, you're not asking for alternative defense counsel to represent you. Is that correct?
Not from the courts, Your Honor. I have trust issues now.
All right. So you are not seeking to have an attorney represent you, someone who has been trained in this field and is licensed to practice law in the state of Colorado. Correct?
On my own accord and effort and time, I am seeking, so.
And you retain that right always, but you're not asking the court to appoint someone else
No, Your
for
Honor.
you. Is that correct?
Yes, Your Honor.
And do you understand that the top charge against you is failure to display proof of insurance, which is a class 1 traffic offense? You could be sentenced to up to 1 year in the county jail if convicted, or you could receive a fine of up to $1,000 or both. And that one is a 4-point offense. Do you understand that?
Yes, Your Honor.
And nonetheless, you're seeking to move forward, at least at this point, without an attorney to represent you.
At this point, yes, Your Honor. I'm still seeking on my own accord.
But you have filed a motion and you're asking the court to set a motions hearing and you don't have an attorney. So I want to make sure that you are validly waiving your right to counsel before I set this hearing.
I'm under the impression that you're telling me that I still have the right to seek an attorney on my own.
You do, but by filing this motion and asking for the hearing to be set when you don't have an attorney, then we need to talk about the waiver. It's not binding. You can change your mind. You can hire an attorney. However, at this point, asking to move forward without the benefit of an attorney and asking you to set court time aside for a motions hearing does require a waiver of counsel if that is how you want to proceed.
I was not under that understanding at all. No one's here to advocate me as far as legal representation to.
So what would you like to do, Mr. Smith?
I'd like to move forward with the motion.
You want to move forward with the motion?
Yes, Your Honor.
Despite not having counsel?
Yes, Your Honor.
And again, just to confirm, is anybody forcing you to do that?
No, Your Honor.
And you understand the rights that you have. You were appointed an attorney, you relieved that attorney of her services, and you did not request new court-appointed counsel, correct?
To an extent.
Now this might sound like a legitimate complaint at first, being lost in the courthouse, not knowing where to go, feeling isolated without legal support. And sure, from a personal standpoint, that can be frustrating. But legally, that's where things change completely. The court system operates on structure, procedure, and documentation. Just because something felt confusing or inconvenient doesn't automatically make it a violation of your rights. And here's the critical mistake. He's bringing up an issue from a completely different case and trying to apply it here. That's like showing up to a traffic hearing and arguing about something that happened in a totally unrelated situation. It doesn't connect, and the judge is about to shut that down quickly. This is where preparation matters, and right now,
My own accord, Your Honor.
All right. I do find a knowing, voluntary, and intelligent waiver of counsel. Certainly, Mr. Smith understands the rights that he has to be represented by an attorney. He was appointed an attorney. He did not ask for a new attorney when the services of the public defender were terminated. You retain the right to hire an attorney at your own expense and on your own behalf if you wish, or seek alternative defense counsel. You are not doing so. So at this point, I do find that knowing, voluntary, and intelligent waiver of counsel. We'll schedule a motions hearing on your motion on April 1st at 1:30. Keep in mind that the court cannot accept a letter from someone who is not here to testify or something similar. So if you're seeking to utilize the subpoena power of the state to obtain the appearance at trial of a witness who you may wish to have testify on your behalf, then you can go down to the court clerk's office and have subpoenas issued. And I believe that we already discussed how to get discovery. Is that correct?
Yes, Your Honor. I was provided that.
All right. So I'll note Mr. Smith believes that he has been provided discovery. I would encourage you, you're not required to speak with the district attorney about the facts of the case, but if you periodically want to inquire of their office whether or not any additional discovery has been provided in your case to make sure that there's that free flow of information, I would encourage you to do so. Anything further for Mr. Smith at this time?
Not from the people, Judge.
And Mr. Smith, is there anything further at this time?
No, Your Honor.
All right, so we're going to set that motions hearing as I've stated, and I'll encourage you to be prepared to proceed to the motions hearing. Anything further?
No, Your Honor.
Anything further, Mr.
No,
Smith?
Your Honor.
All right, and I just want to remind you that any allegations brought up in the motion that you filed in 25T 435 that relate to the infraction case, which was that 25R 549, any of those issues will not be heard. Any rights that you may have from that case are separate and apart from anything in relation to this case.
That line right there? That's not just the judge being sharp. That's the judge sending a very clear message. If you're going to represent yourself, you need to know exactly what you're dealing with. Not kind of know. Not vaguely understand. You need precision. And here's the uncomfortable truth. When someone is juggling multiple cases and can't clearly separate them, it creates the impression that they're overwhelmed or disorganized. And in a courtroom, that's dangerous. Because the court isn't going to slow down to compensate for confusion. This moment also highlights something deeper: confidence without understanding. He believes he's capable of handling this, but moments like this suggest the opposite. And as this continues, the judge is going to start lying.
Sorry about that. No, exactly. It's about your rights. I know my rights. I don't need an attorney. Thank you.
Right, Ms. Matlin, you were here today for an initial hearing. Tender to the court is, has been filed, notice living man, declaration of status. Those are signed by you and have been entered. There's also an affidavit of truth that is unsigned. And so anyway, we're here for an initial hearing and to make sure that you understand your charges. What is your date of birth?
I do not understand. I am here on a special appearance of Thomas Maitland in all caps letters on a special appearance of the case number of 46D04-2602-CM-0250.
Correct, but I need to tell you what you're charged with in this case. So first of all, how old are you?
I'm 29.
All right, what's your birthday?
You guys should already know that, correct, or no?
No, I don't. I don't know what your
I don't
birthday is.
understand. I don't understand.
I just need you to tell me,
Here's the
court.
problem. If we don't know who you are, there'll be a warrant issue for your arrest. So we're trying to get past that level.
Okay.
Okay, so state,
Then you didn't get these papers. I'm gonna give them to you.
okay, so let's back up. My job is to make sure you understand what you're charged with. I have what you filed, and that's made a matter of record. What is your date of birth? Well, you know what? Let me see here.
I'm.
Okay, hold on. I do have it. Is your birth date 9/6 and you're 29 years old? Is that correct?
That is my living man. Yes, that's when I was born, but not this all caps name that's on the docket that you sent me papers for.
Okay, yeah, so
Special
your
appearance.
correct name is, I had that right here too. Well, you signed it, Bo Matlin, what you entered into the court.
Yeah, but not in all caps.
Okay, all right, that's noted for the record. We have an address of 1 Michigan, and is that where you live?
I do not.
Okay, where do you live?
That's me, my person, not this all caps name.
Okay, I understand that. We made a record of that, so that's not a problem.
Okay,
But what I need to know is if that's where you live in Galeen, 110 Eastern.
No,
That's not where you live?
that's where the physical man lives, not.
Building toward this moment. The judge brings it back to one simple, undeniable fact. He had an attorney, and he chose to let her go. And here's where things get uncomfortable. He tries to reframe it. He says he didn't fire her, he just disagreed. But in legal terms, the outcome is the same. She's gone. And more importantly, he didn't request a replacement. This is where a lot of people misunderstand their rights. Yes, you have the right to an attorney. But that doesn't mean you can reject one, refuse alternatives, and then claim your rights were violated. The court gave him options, and he declined them. Now the judge is making him say it out loud, on record.